Now, from CBS News Miami, this is Facing South Florida with Jim DeFede.
Welcome to Facing South Florida. I'm Jim DeFede. We are waiting for a decision by the Florida Supreme Court that would eliminate abortions after 6 weeks of pregnancy, even though many women won't even know they are pregnant by then. For more than 4 decades, the Florida Supreme Court held that abortion was protected by the privacy provision of the Florida Constitution. But this court appears poised to overturn that long-held view. 5 of the 7 justices were appointed by Governor Ron DeSantis, who has swung the court far to the right. Now, we rarely spend any time talking about the Florida Supreme Court, but today we're going to do just that. And I'm going to play some of the highlights of the hearing before the court earlier this month. But first, I think it's important to understand that in 1980, Florida voted overwhelmingly to amend the state's constitution, granting people, quote, the right to be let alone and free from governmental intrusion into the person's private life, end quote. Florida is one of the few states in the country that enshrines a right to privacy in their constitution, and for decades that right of privacy has been used to protect people, and not just when it comes to the right to seek an abortion. It also protects parents, for instance, in how they raise their children. But when you listen to the Supreme Court justices appointed by DeSantis, like Chief Justice Carlos Muniz, there is a belief that voters had no idea what they voted on in 1980.
Well, a big theme of your brief is sort of deference to the democratic decision-making process. And I guess it seems like to the extent that there really was a quote-unquote decision, it's very kind of abstract in the sense of, assuming kind of that people had kind of internalized the sort of legal understanding of a right of privacy, which I think you would have to admit is terminology that in the abortion context, it's not semantically a natural way to talk about it.
The Chief Justice went on to make a few other bold statements. He made clear his views on Roe versus Wade.
Roe versus Wade may have been an abomination. It may have been semantically absurd to talk about that in terms of privacy. But for better or worse, I mean, that was part of sort of our cultural kind of lexicon, right?
And he went on to argue that a 6-week-old fetus is a human being with the same rights as you and I.
You're asking us to essentially take a whole class of human beings and put them outside of the protection of the law, essentially in the sense that if the legislature wants to protect those human beings, they are precluded by the Constitution of Florida from doing that. And at the end of the day, the argument as to why that would be right would be based on a sort of legal meaning kind of understanding of right of privacy.
But while the Chief Justice was not shy about sharing his views, we also know where some of the other justices stand. Justice Charles Kennedy's wife, Jennifer, a member of the State House, was the sponsor of the 6-week abortion ban that her husband will now be deciding. Justice Jamie Grosshands has been fighting against abortion for years and has ties to 2 powerful Christian legal groups, one of whom states that its mission is to spread the gospel by transforming the legal system. All 5 of DeSantis' appointees to the court are members of the Conservative Federalist Society. Now, later in the show, we will talk to State Senator Lauren Book about the court. But after the Supreme Court hearing, I had a chance to talk to the lawyer who defended abortion protections before the court, Whitney White.
I think we made really strong arguments. It's very clear that the law and the Constitution in Florida are squarely on our side. HB 5 violates Floridians' fundamental right to make deeply personal decisions for themselves about whether to continue a pregnancy or have an abortion. That fundamental right has been affirmed and reaffirmed by the Florida Supreme Court throughout decades of precedents. And it has been directly affirmed by the voters as well, who have repeatedly voted to ensure that abortion rights are protected in Florida.
This is all rooted in a protection that the Florida Constitution has that voters voted for in 1980. And it's one of the things that makes Florida somewhat unique to other states is we have an expansive privacy provision in the state constitution that has been interpreted to protect a woman's right to have an abortion. But it also has been cited in other cases and allows other rights for Floridians. If the privacy provision of the Florida Constitution is essentially gutted for this abortion ruling, could that have an impact on other rights currently enjoyed by people in Florida?
Yes, absolutely. The Privacy Clause has always been understood to provide strong protections, both for the right of individuals to make deeply personal and private decisions about their own lives, and for the right to protect our personal and private information from the government. What the state has asked the Florida Supreme Court to do is to dramatically narrow the scope of protection under the Privacy Clause so that it would only protect in private information, and it would provide no protection whatsoever for private decision making. That reading is extremely narrow and it's unprecedented. It finds absolutely no support in the text of the Constitution. It is not something that the Florida Supreme Court has ever accepted before. And in fact, the state has never even advanced this theory until this case. And as you mentioned, in addition to, if the court did accept this drastically narrowing construction of the Privacy Clause, it would not only overrule abortion rights protections, but it would destabilize dozens of other cases in which Florida courts have applied the right to privacy to provide protection for other personal decisions too.
Can you give me some examples of what those are?
Absolutely. So, for instance, the right of parents to make important decisions about the upbringing of their children. The court has also applied the Privacy Clause to protect the right to make important decisions about your own health care in all sorts of contexts. Under the theory that the state has asked the court to adopt, it would represent a dramatic curtailment of individual rights, individual privacy rights in Florida. And I just want to underscore also that the right to privacy in Florida has always been understood to be broader than federal law and to provide more protection for federal law. It's become clear that many individual rights, even if they're protected by federal law now, may not be guaranteed in the future. We saw just last year the US Supreme Court overrule Roe versus Wade and 50 years of protections for abortion rights. One thing that the Privacy Clause was specifically designed to do was to guarantee to Floridians strong protections for privacy rights, no matter what happened under federal law, so that those rights would exist in Florida, no matter what the Supreme Court, the US Supreme Court does. And part of the state's argument would also undermine that relationship, in which Florida voters have repeatedly decided to make sure that abortion rights are protected independently so that they don't have to rely on federal law, and they can look instead to the strong protections of the Florida Constitution.
Voters had the chance to actually vote on this abortion issue in 2012, essentially adopting the position that the state is adopting now, and they roundly rejected it. How does that play into, or how do you think that should play into the court's thinking as it moves forward on this issue?
It's absolutely relevant. So, as you said, the voters have made themselves clear on this issue repeatedly. In 1980, when they adopted the Privacy Clause, that was just a few years after Roe versus Wade, at a time that abortion rights were a topic of national debate. And it really stretches believability to suggest that voters didn't understand that a broad privacy clause in Florida would provide those same level of protections, at least those same level of protections for abortion rights under the Florida Constitution. But even if there were any doubt, this exact question was posed to voters in 2012 when they were presented with a constitutional amendment that would have overruled protection for abortion rights in exactly the same way the state is asking the court to do now. And voters rejected it. They made very clear that they wanted to retain the strong and independent protections for abortion rights that existed in Florida. So if the court were to accept the state's request and overrule precedent now, it would be directly contradicting what the voters said when they weighed in on this precise question.
What would you tell someone who is cynically looking at this from a political perspective? They see that the US Supreme Court overturned decades of precedent in striking down Roe, essentially. They look at a Florida state Supreme Court that now has been overwhelmingly, appointed with far-right judges, mainly by the DeSantis administration, and believing that they believe, looking at this court, that they're not likely to get a legal opinion as much as they're going to get a political decision from the right. What would you say to those out there who look with skepticism as to the legitimacy of the Florida Supreme Court?
It is absolutely clear that abortion rights are under attack in Florida and nationwide. Um, Unfortunately, despite the strong and clearly established protections for abortion rights under decades of Florida law, we have seen Governor DeSantis and his allies in the legislature pass not only this 15-week ban, but also an even more dangerous and devastating 6-week ban that would take effect if the Florida Supreme Court overrules precedent in this case. So it is very clear that there is a serious attack on abortion rights, and that attack is an attack directly on some of the most deeply personal and private decisions that we can make in our lifetimes. And so I think that it's incredibly important for things like independent state protections for abortion rights to make clear that voters do have the power. We do have the power to stand up and make ourselves heard. And we hope that the Florida Supreme Court will hear that loud and clear in this case and will stand by the decades of protections for abortion rights and the repeatedly expressed will of voters on this issue.
When we come back, we'll talk to State Senator Lauren Book, who was there for the Supreme Court hearing. Stay with us. Welcome back. This week, CBS's Norah O'Donnell interviewed Governor Ron DeSantis and talked about his push for a 6-week abortion ban and whether it will lead to women being criminally prosecuted for seeking an abortion.
We asked the governor whether the penalties mentioned in Florida's 6-week ban would include women.
We have no criminal penalty. The penalties are for the physician. I mean, a lot of these
Governor,
women
I read the bill. It says just this. It does include jail time and fines for, quote, any person who willfully performs or actively participates in a termination of pregnancy.
And that's for the providers. It is not for the women.
Is a woman not actively participating in the termination of her pregnancy?
No, because she's not a medical practitioner. So there are
so
no
you are
women.
not for criminalizing women?
No, absolutely not. And that will not happen in Florida.
I want you to keep that exchange in mind as we continue our look at the Florida Supreme Court, which is going to decide if the legislature can create a 6-week abortion ban, even though the state's constitution gives people the right to be left alone from governmental intrusion into their personal lives. In the audience for the Supreme Court hearing was State Senator Lauren Book. We talked about the hearing, the way the governor has stacked the court with conservative judges, and that Norah O'Donnell interview with DeSantis. I started, though, by asking for her reaction to the hearing.
I think it was hostile. I think a lot of the justices were very aggressive in some of their questioning. And when you hear things like the Chief Justice say Roe was an abomination, that they want to protect life at all costs at any stage, a protected class, that strikes fear in the heart of people who want to protect women, want to protect medical freedom and a woman's right to choose. I think that there were some questions on the other side to the state about overturning 30 years of established case law. And I think that the court, unfortunately, while I would never speak for them, is going to turn themselves into pretzels to provide this win to the right.
So you're not confident that, based on the questions that the justices were asking, and it's always challenging, it's always a little risky to try to read the tea leaves based on questions asked by justices, but the tenor of what was being said there, you don't have a lot of hope that the 15-week abortion ban is going to be knocked down, that it's going to go into effect, and therefore then a 6-week abortion ban is going to take place 30 days after that.
That's right. I do believe that's where we are. I think that no one is going to save us but ourselves at this point. While we point to what we can do, to the ballot initiative in 24 and collecting petitions to get to that place, we've triggered a review of the language. But let's be really clear. This court is right-leaning, and I think that they're going to do anything that they can to provide to provide this win to the right. And I think that's a really scary place and time, because as Whitney White said, and as we know, and as I argued on the floor, women are dying. Women are being sent home in really dangerous situations currently under the 15-week ban. Two constituents of mine in Broward County, this is not Texas, this is not some other third world example. These are two women in Broward County who suffered pre-prom, desperately wanted pregnancies. After 15 weeks, their amniotic sac ripped, pregnancy was no longer viable, sent home to develop sepsis before they could receive appropriate health care. That is the world that we're living in today under the 15-week ban. And once it moves to 6 weeks, more and more and more girls are going to suffer and die. That's not hyperbole, that's reality.
How important is the Florida Supreme Court and the moves by Governor DeSantis to take it to the right?
I think that people wouldn't. And I think it goes to even people knowing who their elected officials are, right? They don't know necessarily that I'm their state senator, but they don't know who these justices are. I think it's important. I think it's essential to our freedoms who are deciding the fate of women and girls in this case, but thousands of other issues that affect our daily lives. People don't know who these justices are. But I think when you look at in this context, you've got a justice who worked for crisis pregnancy centers and did work for them. You've got a justice whose wife is sitting in the Florida House who sponsored and fought for this 6-week ban. I mean, these are some really serious issues that are affecting the lives of Floridians every single day. And I don't think that they get the level of scrutiny, but it is so important because, again, these are the justices who decide those things. And the lean of the court, there is no denying what that is.
What do you think the ramifications are if the privacy provision within the Florida Constitution ends up being gutted through this decision?
If they do decide to really give the state this win, and what that would mean is stripping away that extra protection and that privacy clause within Florida's Constitution that we have had for so many years, they will overturn 30 years of established case law. That's cases and cases and cases that they're just going to say, you know what? We don't believe that that's the case. We think that this is the way it should be interpreted, and that's now the law of the land. That should scare everyone, particularly because those are people elected by the people. Those are people appointed by the governor to put those people there. And that is an extreme amount of power that these people are given and have over our daily lives.
Supreme Court justices, are they confirmed by the Florida Senate?
No.
Just he appoints them?
Yes.
No, there's no scrutiny. I think there has to be some sort of judicial qualification commission. Is there some sort of review? How do they get appointed to the court?
They're appointed by the governor. And it has happened 5 times, I think, that the governor has appointed 5 of these justices. Since he came into office, he determines who those justices are going to be. I believe that there are some qualifications that they have to have. I think there's some question about one of those justices, whether they even had the qualifications to become justices. But it's very, very clear that this is appointed by the governor. And there is really nothing that any of us in the legislature can do to change those appointments or confirm them or vet them, quite frankly.
You talked about how this pending ruling and some of the statements, particularly by the Chief Justice, when it talked about, creating a new class, protected class among cells and embryos, that could have wide-ranging implications for a lot of people in the state, including, you talk about issues that you went through yourself. Can you share a little bit more about that and talk about what this would mean if the court ends up taking this extreme position?
This is when I talk about how this issue is really not about a D or an R. This is not a Republican Democrat issue. I was blessed to have my children through in vitro fertilization. My family and I wanted to have children so desperately, as many, many families across the state and across the country do. If you start applying personhood and a special protected class to embryos and cells, that will virtually stop any and all in vitro fertilization practices throughout the state and the country. I have been getting calls from my own IVF doctor about how dangerous and scary this is. Women who understand the implications of what this is. So whether you're an independent, a Republican, or a Democrat, if you came to your family through IUI, IVF, those things will go away when you start applying personhood and protected class to embryos. Like I said to you before this interview, I have an embryo that's sitting in a cryogenic lab that then would apply to be a human being, a person. That is a really, really scary thought. And when you start, again, applying personhood to fetuses, you're going to stop a lot of scientific advancements. And it is scary. It is dangerous. And again, these are people that none of us put into the positions that they're in. And so while I know that people in their day-to-day lives are focused on property insurance, and one day I'm gonna get back on here, we're gonna talk about that, or putting food on the table, or gas in the car, or getting their kids to after-school activities. These are these big, serious issues that are going to be affecting each and every one of us. And you don't know that you needed a right sometimes until it's gone. And I don't want it to be too late, but that is where we're going. That's where we're marching. That is the predominant place that people are. And it's really important. And I'm thankful to you, Jim, for showing people who these people are and what they stand for, because people don't know.
You know, the governor, in an interview with Norah O'Donnell on CBS, talked about the issue of abortion, and Norah O'Donnell had suggested that the way the law is currently written, anyone who participates in an abortion could be criminally prosecuted, the implication being that could apply to the woman seeking an abortion, could become criminally prosecuted if she sought an abortion after 15 weeks or soon to be 6 weeks. The governor said, no, that's not the case. And there is a precedent in an earlier case, State v. Ashley from 1997, that says women cannot be prosecuted. But that was a different time. 1997 and those court rulings, you know, from that time is a lot different from the court that we have today.
To your point, I really can't take stock in, believing that this court will uphold case law that has been established for quite some time, because clearly we're in a place where they don't necessarily do that. I appreciate the governor's position on not wanting to criminalize or send women to prison for receiving appropriate health care. And so I'm working and have put into bill drafting a bill that would ensure in the law, clear as day, that we will not criminalize or go after or put women into prison for receiving health care. Whether that was a case law that was decided over here and we can semantically argue about who, what, where, when, why, or how, then let's make it very clear. And I hope and look very much forward, since the governor has already given his nod to a piece of legislation like this, that the Republicans hear it and it passes as one of the first bills of the legislative session. If that's where they are and that's what they believe, and I hope to have his signature, and I hope that he does it not at 11 o'clock at night in the dark of night. I hope that he's proud to sign a piece of legislation like this. And I look forward to having that and introducing it and having it heard and getting it done, because women shouldn't be prosecuted for getting appropriate health care, for getting the things that they need. Women in the state of Florida shouldn't be sent home to develop sepsis and die or put in harm's way to receive appropriate health care. That's third world. That's not Florida. That's not freedom. That's not the Florida I believe in. And so I'm really hopeful that it's a bill that passes as one of the first of the legislative session.
We'll be right back. Thanks for joining us. You can follow me on the app previously known as Twitter @DeFede, or email me at jdefede@cbs.com. We'll be back again next week. Until then, thanks again for watching and enjoy the rest of your day.